The word maslahah, in its literal sense, means benefit or utility. It is expanded to mean the seeking of benefit and the repelling of harm. If this literal meaning is pursued further, it will lead to something similar to the principle of utility expounded by Jeremy Bentham, which means securing the maximum human happiness. The seeking of human happiness in this sense may imply three things. First, that the happiness sought here is dependent upon human desires or reason. The pursuit of such happiness may or may not coincide with the form of benefit intended by the Shariah. Second, the emphasis in this form of happiness will always be on the collective utility. That is, the happiness of the entire community and the interests of the individual may be given a back seat. Third, the pursuit of pure utility may ultimately lead to the economic analysis of law as expounded by Richard Posner in the Chicago School. In other words, all legal decisions must be reduced to a cost-benefit analysis, either financial or economic. This may or may not suit the goals of the Shariah. Benefit or utility, however, is not the technical meaning of maslahah. What Muslim jurists mean by maslahah is the seeking of benefit and the repelling of harm as directed by the lawgiver. The seeking of utility in Islamic law is not dependent on human reason and pleasure. Al-Ghazali, therefore, defines maslahah as follows. As for maslahah, it is essentially an expression for the acquisition of benefit or the repulsion of harm. But that is not what we mean by it, because acquisition of benefit and the repulsion of injury represent human goals. That is, the welfare of humans through the attainment of these goals. What we mean by maslahah, however, is the preservation of the objectives of the Shariah. Three things are obvious from this statement. First, that the pursuit of human goals and the principle of utility based on human reason is not what is meant by maslahah. Second, that maslahah is the securing of goals or values that the lawgiver has determined for the Shariah. Third, that the goals determined for the Shariah by the lawgiver may or may not coincide with values determined by human reason. Thus, reasoning based upon the principle of utility or on economic analysis may sometimes be acceptable to the Shariah, but it may be rejected at other times when there is a clash of values. Muslim jurists classify maslahah in several ways. These classifications are expected to show us how this principle covers most of the rational sources and how the discussion of the sources is linked with the purposes of Islamic law. We can only list some of the most important classifications without going into details of the powerful structure that emerges. The first classification is according to maslahah, acknowledged by the Shariah, maslahah rejected by the Shariah, and maslahah that is neither rejected nor acknowledged. The second classification of maslahah is on the basis of its inner strength. This yields a division into necessities, needs, and complementary measures. The third classification is into definitive and probable interests. The fourth classification is into public and private interests. A study of the interaction and operation of these categories yields a powerful and fascinating system. Jurists like Al-Ghazali consider this powerful system to have a hold on all the rational sources of Islamic law. This larger doctrine requires that during the use or employment of rational sources to discover the law, each derived law must be checked against the purposes of Islamic law. If there is some compatibility between the derived law and the purposes, then the law is valid. Otherwise, it may be rejected. In this sense, all the rational sources fall under this larger doctrine. Thus, the larger doctrine covers analogy, istihsan, and maslahah mursalah. In other words, each of these rational sources has now become or is deemed a type of this larger doctrine. Shatibi had made a statement that these universal principles are so powerful that if we were to lose all our detailed laws, we would be able to reconstruct them all from these higher principles. Impressed by such views, a few scholars have suggested the alteration of earlier rigid opinions on the basis of these principles. Doing so, however, will be like demolishing the foundation of the building from whose top we are viewing the world. It is a useful exercise to understand all the existing laws through the purposes, but in reality, they are meant to derive new laws for the solution of new problems.